Lori Vallow is arraigned in Arizona, and guess who is asking for a continuance of that trial date? A deputy was found not guilty of shooting his wife, a New York diner robbery gone bad, an update on that mushroom-taking pilot, the Delphi murder suspect, Richard Allen, has been moved to a new prison, an example why criminal defense can be so exhausting, pot psychosis is a thing, and possibly a defense, and then finally, our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications. And remember, you can listen to us anytime on any of your favorite podcasting apps. All right, let's go ahead and open the record for December 7th, 2023. And first on the docket, Lori Vallow. That's right, she appeared in a Phoenix courtroom this morning for an arraignment. Now, this was a week after she was extradited to Arizona from Idaho. And obviously, we know Vallow has been sentenced to multiple life sentences in prison without the possibility of parole back in Idaho back in July of 2023. For the murders of her two youngest children, JJ and Tylee, as well as killing current husband's number 5's wife, Tammy Daybell. Well, now she's facing murder charges for the death that kind of began everything in Arizona. Vallow is accused of conspiring in the fatal shooting of her fourth husband, Charles Vallow, in Chandler, Arizona, and planning the attempted murder of Brandon Boudreaux, her niece's ex-husband, in Gilbert, Arizona, back in 2019. Now, investigators allege that Vallow's late brother, Alex Cox, was the suspect who actually did the killings following his sister's determination that the victims were dark spirits. Yes, it's kind of where it all began. So in court, Vallow stated to the presiding judge that her name was Lori Vallow Daybell. We're going to continue to call her Vallow just to keep the two distinguished. Anyway, she pled not guilty to the charge that had been filed against her. The prosecutor, also present for the arraignment, and said the cases are both first-degree murder cases, and they're very complex. And he wants the currently scheduled trial date to begin, or that's set on April 4th, to be continued. Well, the judge who heard the case today for an arraignment said that she was going to keep the trial date and that the prosecutor can take that matter up with the trial court that's actually going to hear the case. So what have we said here several times on Crime Talk? Remember, the prosecutor, when they bring a case, should be ready to go try that case within the speedy trial time allotted. We saw that in Lori Vallow's case in Idaho. The prosecution was not ready. And when the prosecutor is already asking for an April trial date to be continued, it's telling me they have issues, like we discussed on our Tuesday night live program. That's right. That trial is set for the exact same time as Chad Daybell. Do you think there's going to be some witnesses that need to appear at both? Yes, I do. And when the prosecutor is looking out for the defendant's best interests, be afraid. Be very, very afraid. Now, we'll see. I'm sure the prosecution could muster up their resources and get this case to trial on April 4th. And like we talked about last Tuesday, that's probably the best shot that Lori Vallow would have in prevailing on this particular case. Anyway, in the meantime, the initial pretrial conference has been scheduled for January 18th. We'll go ahead and put that on our calendar as well so we can bring you those proceedings as well. Next on the docket, a not guilty verdict. That's right. A veteran deputy down in Harris County, Texas, who's also known as the bailiff on the TV court show Justice for All with Judge Christina Perez, was acquitted yesterday of murdering his wife. Now, Patricia Spivey was shot twice, once in the arm and once in the chest, on July 28th of 2019, which resulted in her death at the young age of 52. There was never any dispute that her then deputy husband, Raynard Spivey, who's 67, was the one who called 911 and told the police that he accidentally shot his wife twice after the couple argued all day, and they eventually had a little tussle with the gun. Now, according to court documents filed in the matter, the day after the shooting, Patricia Spivey was found dead in the master bedroom closet, where 3 shell casings were visible and a pistol was left on top of a clothes hamper. Well, Renard Spivey, who was shot in his left leg, dialed 911 around 3:12 a.m. on July 28th of 2019 and called for an ambulance. Ladies and gentlemen, the jury has spoken. It's obvious, right? People oftentimes fight and then accidentally get shot in the closet, right? It happens all the time. Anyway, accidental self-defense, I guess. Anyway, not guilty. Congratulations to Mr. Spivey and his attorneys. Next, a New York robbery gone bad. So the New York police are searching for a suspect who shot a man in the face during a late-night robbery of a seafood restaurant. Now, the victim was dining at the Seafood King Fish Market in Washington Heights just before 2 a.m. on Wednesday when the shooting took place. Now, we can't show you all of the surveillance footage, but what we can shows the suspect was literally moments away from just walking out of the store with a bag full of cash and a bunch of cell phones when he basically turned around and decided to shoot the victim. Now, Lieutenant John Russo said, quote, "I don't know if the victim saw it coming. The victim had just had his property taken, his cell phone and money, and was eating. And I'm sure was watching the encounter with the second victim, who was an employee at the location. And then it seemed like the perpetrator was running out the door. He turned around and fired a shot, striking the victim in the head." Now, the witness said the suspect first sat at the counter and ordered food, then left the restaurant, returned to the bathroom, then commenced with the holdup. Now, the cashier at the restaurant filled a plastic bag with cash from the restaurant and her cell phone. Then the suspect told her to get down behind the counter before shooting the victim. Police described the suspect as 5'5" with a medium complexion and was said to have been wearing a black mask and a black clothing. They also noted that he was brandishing a blue handgun. Now, 1 9mm shell casing was recovered at the scene, and the victim was ultimately taken to the hospital in critical condition. Crazy. We needed something like a scene from Pulp Fiction. Like, you don't want to do this robbery, son. Go away. Go away. But apparently in New York, people can't have guns. Only criminals apparently do. So nobody could say, no, I think not. Today is not your lucky day. Go away. Anyway, an update on the mushrooming pilot. Remember the off-duty pilot who almost brought down a passenger jet while tripping on some magic mushrooms? Well, he's been indicted on 83 counts of reckless endangerment and obviously avoided the much more severe charges of attempted murder. The reckless endangerment charges are all misdemeanors. So Joseph Emerson said that he took psychedelic drugs just 2 days before the flight on October 22nd while on a weekend getaway to remember his late best friend. Now, the grand jury there in Multnomah County decided Thursday to only charge him with 83 counts of the reckless endangerment, like I noted, all misdemeanors, to represent every person on board the plane. Now, Emerson also faces 1 felony count of endangerment of an aircraft in federal court, and he's pled not guilty to the attempted murder charge as well. So the pilot's attorney, a guy by the name of Noah Horst, believe that they'll be able to get him out of prison by the end of the week. Now, the attempted murder charges were never appropriate in this case because Captain Emerson never intended to hurt another person or put anyone at risk. He just wanted to return home to his wife and children, his attorneys put out in a statement. Simply put, Captain Emerson thought he was in a dream. His actions were taken in a single-minded effort to wake up from that dream and returned home to his family. Unsatisfied with lesser charges, Emerson's attorneys believe their clients deserves to get off completely scot-free, noting that the grand jury is a largely secretive process controlled by the prosecution, and the defense counsel are not permitted to make any arguments at the grand jury. They added, all true, but that's the way the system works. Thus, while we believe that the district attorney's office treated Mr. Emerson fairly, we do not know why the grand jury arrived at its charging decision, nor have we had an opportunity to examine all the evidence that the district attorney ultimately presented to the grand jury. Rule number 1, don't make statements until you've seen all the evidence, because oftentimes you got to eat your hat, so to speak. Trust me, I know. Anyway, so you keep your mouth shut till you've seen the evidence. You don't criticize the district attorney who gave you a bunch of misdemeanor counts as opposed to a bunch of felonies. Let's face it, the dude was tripping on magic mushrooms in an airplane. He tried to hit the fire extinguisher bottles. Do you think you would want that to happen if you were in the back of the airplane, or even in the front if you were the pilots? No. And guess what? This guy's had his pilot privileges suspended, and frankly, he should never have them back again. I don't want to sound like some sort of teetotaler, but I'm telling you, if someone is operating heavy equipment, I don't want them drinking, and I don't want them tripping on magic mushrooms or whatever the drug of their choice is. It's reckless, it's dangerous, and he's lucky that all the crew and him and the other 83 people on that plane didn't go down and perish. Now, violating another rule, which is never talk to the media while you're in custody, in an interview with the New York Times from the county jail last month, former or soon-to-be former Captain Emerson, he's been fired, but he offered a little glimpse into the bizarre catastrophe or near catastrophe where he almost killed 83 people, urinated on himself, stripped naked, and tried to flee from custody. So Emerson said that he had been feeling his grasp on reality was shaky for 2 days before the flight, and had texted his wife moments before taking off how desperate he was to simply return home, telling her, "I just want to hold you." With 83 passengers on board, Emerson was off duty and should have had an easy flight to San Francisco, headed home, and he was allowed to sit in the jump seat up in the cockpit. But the other pilots said that he quickly showed signs of a little erratic behavior. And the plane reached cruising altitude. He threw off his headset and declared, "I'm not okay." Suddenly, Emerson grabbed the plane's overhead emergency fire suppression handles, leading to a desperate struggle between him and the pilots to keep the jet in the air and that he not deploy the fire extinguisher bottles. The flight was forced to change course and make an emergency diversion to Portland. And once on the ground, Emerson was charged with 83 counts of attempted murder, a charge for all of his near victims on board. Ultimately, he noted that the incident was the result of a psychedelic bad trip that he couldn't shake off. Don't care. Guess what? Voluntary ingestion of drugs, alcohol, not a defense. My gosh, if that were the case, ladies and gentlemen, guess what? No one would be in custody because most of the crimes are alcohol or drug induced. So I get it. A lot of people want to take magic mushrooms, and I'm sure it can help people. Don't get me wrong. I just don't want you operating an airplane, at least not one that I'm on. Do you want the pilot that you're flying the plane on to be under magic mushrooms and tripping and having a bad trip? Yeah, I don't think so. Next, Richard Allen, the Delphi suspect, has been moved. That's right. Richard Allen has been moved to a different prison. Remember, that's all his previous attorneys had asked for. So according to documents filed Wednesday in Mr. Allen's court case, where he's obviously been charged with the 2017 killings of Lively German and Abigail Williams, well, he's been transferred to the Westville Correctional Facility in LaPorte County in the Wabash Valley Correctional Facility in Sullivan County on December 6th. Now, I'm not familiar with any of those prisons, and frankly, normally what happens when someone is in pretrial detention, they stay in the county jail. But in this particular case, apparently the state in Indiana has the ability to place somebody in custody in the prison system to keep him safe. Now, as you may recall, Allen's previous attorney had filed a motion requesting that he be moved to a new prison. At that point, he had been at the Westerville Correctional Facility for around 6 months. In that filing, Allen's attorneys described his conditions as akin to those of a prisoner of war. They laid out a list of treatment Allen had allegedly experienced. Allen's cell was described as being 6 feet by 10 feet in size, pretty standard. His sleeping on a pad on a concrete floor, pretty normal. only allowed to shower 1 or 2 times per week, not unusual, and they required him to wear the same clothes, including underwear, for days. They were apparently soiled, stained, tattered, and torn. Not unusual in jail. Apparently, there was no opportunity as well for Mr. Allen to visit his wife or family members in the past 5 months. And the electronic tablet he uses to call family members is being monitored by prison officials. All normal. And all the cost of the calls were being paid for by Mr. Allen or his family. Pretty normal. Allen was afforded very little recreational time. Usually it's 1 hour every day. Pretty normal. And information Allen's attorneys provided to him to review as part of his defense were yet to be provided to him weeks after they were submitted. And it's difficult for his attorneys to meet with him given his segregation and isolation, which keeps him from being able to communicate with his attorneys. Frankly, ladies and gentlemen, none of that is particularly shocking to me whatsoever, but they made that argument to get their client moved. Or could it have been all the Odinites that were working in the jail, as they also alleged in their motion? Could be. Or not. I don't know. Anyway, as you may recall, Allen's attorneys issued a pretty forceful response to the Indiana Supreme Court, urging them to remove the judge in the Delphi case and reinstate his original attorneys. And they are also calling for his trial within 70 days of the court's ruling in the Indiana Supreme Court. In the filing, the attorneys claim that they should be able to assist Mr. Allen in his defense. Now, Judge Frances C. Gull severed Allen's attorney-client relationships on her own motion and over Mr. Allen's objection. Now, not a single Indiana case has tolerated similar behavior from a child judge, the attorneys have noted, and Allen repeatedly asked to keep his original attorneys, but the judge acted anyway. Now, the judge's actions delayed him from having a speedy trial, Mr. Allen's attorneys allege, and appealing is not an option because Mr. Allen cannot have a speedy trial without his original attorneys. Now, this extraordinary writ is the only remedy that they allege, and any trial without Mr. Baldwin and Mr. Rozzi, Allen's counsel of choice, would be merely for show. Now, only 2 lawyers can be ready for a speedy trial and carry that out. And guess what? It's Rozzi and Baldwin. And the attorneys for Mr. Allen also note that they are the only attorneys that can handle this case, and therefore the attorneys should be in fact reinstated. The attorneys also allege that if the Allen is not taken, Mr. Allen's trial will be delayed longer and even more public resources be spent. But more importantly, the public trust in the judiciary will be permanently undermined while the world watches. Judge Gull's argument is that the Delphi murder case and the Indiana Attorney General's office argued that the Indiana Supreme Court should not grant Mr. Allen's request to reinstate his original defense team and remove the judge. In her argument, Judge Gull claims she made her decision to remove Allen's original defense team for gross negligence and because she believes they compromised his defense. The judge claims that the argument against her decision was never made in the trial court, and therefore it was not preserved for appeal. Additionally, she said that if she had made a ruling on Allen's attorneys, that they could have appealed her ruling instead of going directly to Supreme Court in this case. Judge Gull argues that Allen's right to choose attorneys Baldwin and Rozzi to represent him is outweighed by his right to effective assistance of counsel. She notes that the respondent acted well within her discretion to remove Baldwin and Rozzi over their objections, and the record supports that the trial court could reasonably conclude Baldwin and Rozzi committed multiple violations of the rules of professional conduct, compromised Mr. Allen's defense, and that the totality of the circumstances demonstrated gross negligence and incompetence on the part of the defense team. She argues that she requests to have a trial within 70 days of the Indiana Supreme Court should not be granted, as Allen's current defense team asked that the trial date be pushed back to October of 2024. Hopefully we'll have a decision from the Indiana Supreme Court here, maybe before Christmas or shortly thereafter. Next on the docket, let me give you an example of why being a criminal defense attorney can be quite draining. This is just one example. All right, so 2 days before a defendant was scheduled to be sentenced for killing her friend, Jesse Kurzweski, attorneys filed a motion to withdraw from the case. And in a phone call from the jail, Kurzweski said she doesn't know what will happen next. Now, Ms. Kurzweski was convicted of killing her friend Lynn Hernan by poisoning her with eye drops. The jury deliberated for about 11 hours before returning the verdict last month, and sentencing was scheduled for December 7th. But the hearing is obviously continued. And then because on November 30th, Donna Kutchler, one of Kurzweski's attorneys, filed a motion to withdraw from the case. And then Kurzweski's other attorney, Pablo Galvez, also filed a motion to withdraw. Now, in a phone call with a news organization, Kurzweski said that the attorneys withdrew because of an alleged letter the prosecutors have accused her of sending from jail. Apparently, there's a 37-page letter that was written to a friend identified only as Jessica and reportedly contains instructions from the defendant for creating a tape recording that would pretend to be from Hernan and claim that she died by suicide. Now, the letter allegedly details the characteristics of Hernan's voice and suggests you could even have a movie or music on in the background to help distract. To be clear, I did not write, send, or have any involvement in these new developments that the prosecutors put out yesterday, Ms. Kurzweski said. I did not send anything. I did not ask anyone to do anything, nor did any attorney say or do anything or were involved in anything either. As far as somebody being Lynn on a tape, that is absurd. As many of us know her voice and would still be able to recognize it, you cannot disguise or try to be someone else. Now, Kurzweski said that she wanted to make a statement to break her silence as she maintains her innocence despite her conviction by a jury of 12, a jury of her peers. She said, quote, I was silenced by a protective order early on, so I could not talk. And after many conversations with my attorneys, I chose not to take the stand, which I extremely regret. My mother was not allowed to take the stand, which was also a huge loss in the defense. I sat in the courtroom every day during the trial while everyone talked, and I had to sit there and quietly. It was extremely hard. I plan on finally speaking out at my sentencing, but I no longer can wait. It's time to speak. She cannot be silenced. Well, the motion to withdraw is scheduled for a hearing in late December. Now, Ms. Kurzweski faces mandatory life sentence for the homicide conviction and additional 10 years. So you may say, why is this an example of your being difficult to be a criminal defense attorney? Well, you have a defendant that proceeded to trial. All right, fair enough. But then she gets convicted. She states that she was going to testify, but she didn't testify, and her mother didn't get to testify. No, the attorneys didn't call the mother, more than likely, because of tactical decisions. Maybe she'd had nothing relevant to say. Maybe there's something that if she testified to something good, it would be far outweighed by what the prosecutor knew, and that would come out. So it's a tactical decision. And then her to say that she was going to testify, she should have testified, she regrets not testifying down the road. Well, that's buyer's remorse, ladies and gentlemen. And you can only get one shot at whether you're going to testify or not. And then you don't, and then you bitch and complain, and you're going to blame their attorneys for the next 25 years. It's exhausting. And unfortunately, sometimes the courts go along with this and they allow this nonsense to take place. If the attorneys make the record, that's what you rely upon. Not 20 years down the road in some post-conviction proceeding saying that the attorney didn't do something correct. It's ridiculous. Or saying that they killed me off the stand. I hate that kind of nonsense. Next, this is a little weird. Pot psychosis. So Bryn Speecher of Thousand Oaks, California, picked up a bread knife and stabbed her boyfriend 108 times. I mean, we've all been there, right? It happens. Needless to say, it killed him before she turned the blade then on her dog. Well, the woman who worked as an audiologist then proceeded to stab herself, only stopping when police had to hit her 9 times with a baton. Well, last Friday, Speecher was convicted of killing her boyfriend, Chad O'Malia, then 26, and was awaiting sentencing. However, testimony from an expert witness called by the defense paints a vastly different picture of the perpetrator than the story would suggest. So, forensic psychiatrist and expert witness, a guy by the name of Dr. Chris Mohandy, told the jury last month that Speecher was a normal girl with no history of mental illness or violence who was committed to doing good in the world. And on the night in question, her brain was completely overtaken by extreme psychosis induced by marijuana that had been supplied by her boyfriend. So in testimony from Speecher herself, the healthcare professional said she'd smoked weed only a few times before and had never really been high. And her attack was launched because she had lost touch with reality as cannabis triggered voices in her head. Now, Dr. Mohandy warned people with no prior history of violence can consume cannabis even during one session and then proceed to commit acts of physical violence to themselves and to others. I think that's interesting because most people always say pot chills you out. Anyway, we continue. Now, other psychiatrists for the defense said they were 100% certain that the attack had been caused by weed. Now, Dr. Mohandy, who had seen at least half a dozen cases like this one, used his position on the stand to warn against widespread legalization of the psychoactive drug. Now, it's yet another drug that people think is safe because it's legal, and now more people are trying it. But it's more potent than it's ever been, and it's problematic, said Dr. Mohandy, who has testified in 80 cases, including several involving marijuana. He stated, quote, "So people say it's just marijuana, and they try it and make it seem like it's insignificant, and how could this possibly happen?" Well, that doesn't really fit with his professional experience. He stated, Speecher's behavior is well documented in his opinion of psychosis. The things she was saying, what she was doing was consistent with psychosis, the psychotic behaviors that she would later explain to investigators and detectives as well as to the doctor. Now, the nature of it, the spontaneous thing she was saying, it was consistent with the delusion and the command hallucinations and the voices that she claimed she heard later on. The doctor added that her use of cannabis caused delusions and hallucinations, and she lost touch with reality. The doctor also testified for the prosecution, saying he fully agreed with the testimony for the defense. Now, Dr. William Wershings, clinical professor of psychiatry based in Los Angeles and acting for the defense witness, said he was 100% certain that Speecher's attack was due to cannabis-induced psychosis. And he said, quote, "I don't think I can be 100% certain about anything, but this is certain as I can be about anything." He had most people have the belief that marijuana diminishes violent potential. When compared to drugs like cocaine and perhaps methamphetamine, that's absolutely true. Compared to nothing at all, when compared to room air, definitely not. Now, the defense has described Speecher as being a good character. She had no previous convictions or record of mental health problems, and Dr. Mohandy said the psychological tests he carried out on her in January showed that she was a very normal person. He said there was no evidence that she tried to malinger or play up what she was sick of or had any problems. There was nothing extraordinary about any of the results. She had a normal, what I would call a defensive profile, the doctor noted. And testimony from the expert tallies with the previous reports about Speaker's character. Now, back in 2018, her grandmother's psychiatric nurse, Patricia Pierce, wrote a letter to the court detailing the nature of her granddaughter. Now, Speecher is steadfast in morals, honesty, life choices regarding citizenship with the Girl Scouts and church, healthy family and friends. She was never been violent or trouble with the law. She's been a gentle and compassionate, wrote the grandmother, and hopes for leniency. She also described a picture of a wholesome child raised in the suburbs of Chicago who grew up to become an audiologist against all odds because she has a hearing loss and speaking issues herself, apparently. Now, at the time of arrest, like I said, Speecher wears a hearing aid and was in her first year with UCLA Health in Thousand Oaks, having moved there from Chicago in 2017. On the night of attack on May 18th, Speecher had gone to Amelia's home, who she had heard they'd been seeing each other for a couple of weeks. Shortly after inhaling smoke from 2 hits of Amelia's bong, which she used almost daily. She rushed to the bathroom and said she started to hear voices in her head. Then she went to the kitchen and took 3 knives from the block before stabbing Amelia, her service dog, and then her own face. When the police arrived, they found Speecher drenched in blood and kneeled over Amelia's corpse. She was stabbing herself repeatedly in the neck, with officers unable to get her to stop until they hit her with a baton. Now, the body cam footage of the scene when they arrived in 2018, viewed by Dr. Mohandy, rated Speecher's psychotic state as a 4, the most severe state when someone is harming someone else or themselves. He added a video of someone acting psychotic is pretty powerful evidence. So some of the stuff would be pretty hard to fake on the fly, and you can see and hear responding to voices. It's what the doctor would call florid psychosis, meaning it was outwardly manifested and highly salient. Now, cannabis-induced psychosis is when someone suffers hallucinations or delusions after taking cannabis. Doctors say the drug can cause an imbalance in hormones in the brain, including feel-good chemical dopamine, triggering mental illness. Although the risks are thought to mostly affect regular users who have been exposed to drug over many years, doctors are increasingly seeing mental illness in infrequent users. So apparently this could be linked to the increased THC content in cannabis products, which is now several levels above what is produced naturally by the plant. I've seen it, ladies and gentlemen. Had a guy, literally, he and his roommates did nothing for hours and hours a day but smoke pot. Became super paranoid, heading to the airport, punches somebody. Just because. Paranoia. Totally psychotic. I know, people don't think marijuana, oh, it's just marijuana. Hey, like I said, I want to sound like a total teetotaler. I wouldn't tell you to do it. Certainly wouldn't tell my kids to do it. Nothing good has come from it. Now, I know people, there's going to say there's medicinal purposes. I get it. Helps people with anxiety. I get it. But like anything, too much of it and too much of anything can be bad. Next on the docket, our dumb criminal of the day. A Florida man, I know, shockingly, wasn't that? A Florida man was arrested Saturday after he allegedly refused to pay $250 for the tattoo that he received from the Ink Gods shop in St. Petersburg, Florida. Now, the guy's name, Max Alexander Krejcant, Krejckant. We'll just refer to him as Matt. Anyway, this Florida man was arrested Saturday after he allegedly refused to pay for the $250 tattoo that he received from the Ink Gods, spelled Godz, shop in St. Petersburg. Well, Max was reportedly under the influence when he got, wait for it, the Waffle House logo. Now, while the restaurant's chain's emblem is yellow and black, Max's tattoo, about 5 inches wide, was gray and black. And since he did not want to pay for the additional $100 for the yellow ink, the Ink Gods owner explains why he refused to pay. So when it came time to pay for the tattoo, Max refused all options to satisfy his debts. And needless to say, the police were arrived, and when the police arrived, they frisked Max. And what did they turn up? $6 and a driver's license and no other money on his person. Well, Max was charged with theft. He got to spend a night in jail after posting $150, and he's pled not guilty to the misdemeanor count. In addition to his Waffle House art piece, in evidence, there's apparently several tattoos, including a black and white tribute to Insane Clown Posse on his forearm. Now, I think the thing that's interesting about this is old Max couldn't come up with the money to pay for the tattoo because he had $6 and a driver's license. But as soon as he was thrown into the pokey, miraculously, they were able to find $150. So, ladies and gentlemen, there is some benefit sometimes for people going to jail. Just noting. So hopefully that money will be held And when the case is resolved, that money posted for the bond can go to pay the restitution. Max, don't get tattoos while under the influence, and make sure you take enough money to pay for them. All right, that's all we have for you today, ladies and gentlemen. Thanks for watching. We'll see you next time on Crime Talk.